You're tuned in to Agriculture Today, and we start our Wednesday show with an agricultural law update. And as always, we're joined with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, we're talking about a few different topics today, and the first one being buying farmland with a growing crop and how that's a unique issue.
Well, it's an important issue from a tax standpoint for several reasons, one of which is if I'm buying land with a growing crop on it, I can't take any allocated deduction for that crop. In other words, when we buy farmland, what we like to do from a tax standpoint is we allocate value to the different items of property that we're acquiring it. So fences, irrigation equipment, whatever it might be, and we set that up and depreciate it. Well, I can't get any deduction for a growing crop, so there's no separate allocation for that value.
And so kind of cost being an issue of how much do things actually cost, because who knows what the crop will be.
Right. And I would say the IRS has not been clear on the issue with respect to a growing crop. But what I think you do is you capitalize the crop into the land itself, and then you get a deduction when the income from the crop is reported or fed to livestock. And that could be in a different tax year than the year in which the crop is actually sold. So it depends on whether there's a deferred payment contract that's involved or not, and becomes a timing issue for clients.
And is there maybe another option that producers might want to look into before buying the land?
Yeah, one thing is maybe to lease the ground before you buy it. If you know you're going to buy it, maybe you can structure an arrangement with the seller that you could lease the ground. Therefore, you get the deduction for the input costs associated with that crop on the ground that you're buying. And so, therefore, if you buy it during that term, you're the farmer. You have been the farmer all along. You get to claim the deduction. But that requires some pre-planning.
And if leasing isn't an option, who should maybe producers talk to before pulling the trigger to buy that farmland?
Well, they should talk with their tax advisor. And hopefully the tax advisor is aware of these things and can help them structure those arrangements, or at least suggest what you should do to get the best tax advantage for your position on your return before you actually buy the land.
And Roger, another important topic to probably a lot of producers is what is livestock, and why is the definition of what is livestock important?
Well, the definition of livestock can vary depending on for what purpose we need the definition for. And, for example, there are certain instances in the tax code where bees count as livestock, poultry count as livestock, but yet for other definitions in the tax code, other purposes of the tax code, bees and poultry, for example, don't count. Bees would be insects, and they don't count as livestock. And what I mean by this is there are favorable rules in certain situations that apply to livestock, and if what we're talking about doesn't qualify as livestock, then you can't take advantage of those rules.
What about livestock being a pet versus farm animal?
Well, we see that come up frequently in zoning issues. There might be a zoning ordinance in town or in a homeowners association that says that you can't have livestock. Well, I've got a potbelly pig. What's a potbelly pig? Is it a pet or is it livestock? For those old enough to remember, I tend to see tax in just about everything that seems to move. My wife accuses me of having this problem. You remember the old show Green Acres. It's before your time. But Arnold the pig was on Green Acres. Now, is Arnold livestock or is he a pet? And that comes into play when you have an ordinance that says you can't have livestock. Well, I don't have livestock. I have a pet pig. So what is it? So you have to be very careful if you're a drafter of an ordinance, or you're a drafter of a zoning law, or you're a board president of a homeowners association and you want to get a resolution passed that says we don't want livestock in our homeowners association. Well, you can't just say livestock. So because you get into these side issues. For example, if I've got a homeowners association or I've got a small town or whatever the case might be, and I'm prohibiting livestock, but yet I have somebody that has some bee boxes, some beehives in their yard, is that permissible or is it not? So we often get into the issue of what is livestock from a zoning perspective, but we can also get into it from a tax perspective too.
Also with what is livestock, sometimes the factor of being unborn livestock or even semen gets thrown into that mix. Yeah,
semen is wannabe livestock. That's not livestock yet. And so we often think of that with respect to security agreements when if I'm a lender and I want to take an interest in a farmer's collateral and I'm defining it as livestock and so forth, well, semen's not going to be picked up in that. I have to specifically state that. And that can be a big issue depending on what that farmer is doing. Maybe they're doing artificial insemination, which, by the way, is what I thought AI always referred to. Now that refers to something else that I was totally caught off guard by that. By the way, I did see a flyer at the law school. We were having an AI symposium. And I thought, well, wait a minute, why wasn't I invited to this? We're talking about artificial insemination, and some of the other professors looked at me like I was from Mars. What? It's artificial intelligence. I said, well, okay, we're talking we got two different worlds going on here. In ag, that's artificial insemination. But if we're a lender to a farm client that is engaged in providing breeding services, well, then we want to retool our security agreement and financing statement to say livestock products thereof and unborn young of livestock, including semen. We need to be specific as well as general. So it makes a difference in a number of areas of the law that we often don't think about.
So for producers, if they're kind of in a bundle, they really need to make sure things are spelled out before agreeing to anything.
Yeah, in a whole host of areas, whether we're talking tax, whether we're talking zoning ordinances, whether we're talking a security agreement. Yeah, draft broadly. What I like to tell lawyers is draft broadly, but then be specific so that you catch it.
And something else important to livestock often is going to the vet. And recently in your article, you wrote about a veterinarian's lien.
Yeah, under Kansas law, as is in the case in many states, a veterinarian can get a lien for their services that they haven't been paid for. So a farmer goes or a livestock owner goes to a veterinarian, has services rendered for an animal or for their livestock herd, and or the vet comes out to the farm or the ranch, renders the services, and if they don't get paid, the vet has a lien that they can ultimately enforce, and they can levy on some of the other assets of that farmer or garnish wages or something to satisfy the lien. The interesting thing about a lien, and the important thing about a lien, is that it has priority status over a prior perfected secured lender. So if the farmer has already pledged the cattle, for example, if it's cattle that were being treated by the veterinarian, if they've already been pledged as collateral on a loan to the primary lender of that farmer, say a bank, and a vet provides services that weren't paid for, the vet's lien will come first before the bank if it's properly perfected. You have to file to get super priority status. We had a recent case in Kansas where a vet did provide services, tried to assert his lien, but it was such a weird set of facts. He didn't know who actually brought the livestock to his office. He had worked on them in the past. He knew whose animals they were, but there was no note. They just showed up in a trailer, and so he cared for them for a period of time and ultimately wanted to get paid, and the owner of the livestock said, well, I didn't take them there. I don't know who did. There were a bunch of funny things going on in this situation. Long story short, he wasn't able to enforce his lien because he couldn't prove that the owner requested his services. But the key point on this is if you have a lien for your services, the vet lien, that will come before a prior perfected security interest if it's properly perfected.
And so a good choice to just avoid it is make sure you pay your vet and know what's actually happening with them.
That would be great. That would keep us lawyers out of these things.
And Roger, one more thing that's been in the news quite a bit, talking about ERC claims.
Yeah, the employee retention credit is just riddled with fraud. In fact, it's gotten so bad that the IRS announced in September that they were going to stop processing claims for the fourth quarter of 2023. And so it's just put a halt on everything. And even those people that had valid claims, they can't get their claims processed. So these small businesses that had a valid claim aren't going to get their credit, which they need at this point in time. And now this, again, was all virus-related legislation. And it's put together quickly, and the scammers have jumped all over it. What IRS has said now, and frankly, with respect to farms, farmers may have been misled that they're eligible for this. I don't think there's going to be very many farmers that are, because you had to show a 20% reduction in revenue. Well, even during the virus-related years and the government shutdowns that were mandated, farmers didn't have a drop in revenue. In fact, the revenue may have gone up. But they may have been coached into filing a claim by these mills that are cranking out these ERC claims fraudulently. And so what IRS has said now is, okay, we're stopping processing the claims until we can get our arms around this mess, and we're going to provide amnesty. And so if you think that you submitted a fraudulent claim, you can withdraw that. There's a procedure for withdrawing it. If you're currently under audit, you can request withdrawal to the auditor and back out, no questions asked. If you've received a refund check and you haven't cashed it yet, you can send it back with a note on it saying that you're withdrawing your claim. No questions asked. You're out. No penalties. Nothing. So in my article that I've written, I've shown what the steps that you need to do and what you have to file to get that.
And where can people read that article, Roger? A
couple of places. My blog article can be accessed through my blog, which is accessible off the homepage of my website, which is washburnlaw.edu/WALTR, or on Ag Manager.
Roger, I appreciate you taking the time to join us today and give us an agricultural law update.
Thank you, Shelby.
That was Kansas State University and Washburn Law Professor Roger McEowen. Once again, you can find his blog with this information in it by going to washburnlaw.edu/WALTR. Again, that is washburnlaw.edu/WALTR. I will link it in today's show notes, which you can find on agtoday.net.